between Mr. Louis Olustagbemi. Parties are absent, right?
Yes.
Yes, appearance.
Good afternoon, my lord.
Okay, respectfully, my lord.
Yes.
Dr. I.O. Ebetule. I humbly appear for the
Doctor.
claimants, my lord.
Yes, I.O.
Ebetule. Yes, my lord. Most grateful, my lord.
Yes.
My lord, good afternoon. May I respectfully announce appearance for the defendant, OU.
Yes, what is your name?
OU.
Yes.
Wanya.
Yes.
Respectfully appear for the defendant.
Yes.
Lord, I'm grateful.
The matter is for judgment and the judgment is ready. The claimant commenced this action by way of complaint and accompanying processes filed on the 25th day of October 2023. The claimant also filed a statement of facts, affidavit in verification of complaint, witness statement on oath, and list of documents to be relied upon at trial. By the complaint and statement of facts, the claimant sought the following reliefs against the defendant. 1, a declaration that the defendant's act of withholding the late Mr. Omase Oris Shemed, accrued salary and terminal benefits entitlement for over 7 years now is an unfair labor practice and illegal. 2, an order of court directing the defendant to pay claimant the sum of 516,547 naira 4 kobo, being the aggregate of respective sums unilaterally deducted from the late monthly salary of May, June, July, and August 2015, same having been deducted by the defendants without the deceased consent or authorization. 3, an order of court directing the defendant to pay the claimant the total sum of 1,873,979 naira 24 kobo, being 4 months accrued salary owing to the late Omiseye Jemide as at the date of his demise. 4, an order of court directing the defendant to pay to the claimant the sum of 506,172 naira 27 kobo only, computed at the late Mr. Omose 1 month's basic salary plus 1 month transport allowance, being the deceased annual leave allowance entitlement with respect to year 2015. 5, an order of court directing the defendant to pay to the claimant the sum of 5,580,226 naira 56 kobo only, being the cumulative of the late Omose long service compensation by the defendant's staff manual, computed at the monetary equivalent of the deceased 2 month, 4 month, and 6 month basic salary for employee who reach the work milestone of 5 years, 10 years, and 15 years in service respectively. 6, an order of court directing the defendant to pay to the claimant the sum of 16,714,679 naira 68 kobo, being the late Mr. Omose Tabi's basic monthly salary, that is 465,018 naira 88 kobo times 36. The late Omase, having served the defendant meritoriously for over 15 years before his demise, which sum is payable to the deceased estate. 7, an order of court directing the defendant to pay the claimant the sum of 13,663,651 naira 65 kobo only, being gratuity payable to the late Omese, computed at 150% of the deceased monthly gross salary, multiplied by 15, the deceased having served the defendant for over 15 years. 8, an order of court awarding damages in the sum of 10 million naira against the defendant for its failure to pay the late Omese accrued salaries entitlements for over 7 years, contrary to its own staff manual and despite repeated demand thereto. 9, an order of court awarding in the claimant's favor the sum of 19,966,330 naira 8 kobo only as damages or compensation for negligence and or breach of the claimant's employment contract to ensure the late Omese under the defendant's group life insurance as statutorily required and as stipulated in the defendant's staff manual, and or for neglecting to ensure the said payout. 10, the sum of 1 million naira being cost of this action. 11, an order of court awarding 10% interest on the margin or cumulative judgment sum till same is fully liquidated by the defendant. The defendant entered a memorandum of conditional appearance on the 26th day of February 2024. Subsequently, the defendant filed a motion on notice dated 26 February 2024 and a statement of defense dated 5th March 2024. The claimants filed a reply to the statement of defense dated 13th March 2024 and a further witness statement in response to the defendant's statement of defense. On the motion on notice, the defendant applicant filed a motion on notice dated 26 February 2024, brought pursuant to Section 16 of the Limitation Law Number 7, Cap 80 Laws of Rivers State 1999, Order 18, Rule 2, Sub 2 of the National Industrial Code of Nigeria Civil Procedure Rule 2016, and under the inherent jurisdiction of this honorable court. The motion was argued by counsel for both parties, and by the agreement, by the ruling of this court, the ruling on the motion was adjourned to be delivered along with the main judgment. The motion is praying for the following reliefs: an order of court dismissing this suit for want of jurisdiction as the action is statute bar. Other processes filed by parties in response to the motion. The claimant respondents filed a counter affidavit dated 29 February 2024 and a written address in support of the counter affidavit. The defendant applicant subsequently filed a reply on points of law dated 4th March 2024. From the motion and the various processes filed, the sole issue for determination in this motion is whether the suit is statute bar, having been commenced after the lapse of the period prescribed by statute of limitations, statute for initiating such an action. I reproduce the summary of, I'll summarize your submissions. Due to the time, I still have 2 other judgments, so I will not read it. When you get the ruling, judgment, you will read it. I will go to the ruling itself. The facts giving rise to this motion are in serious dispute. The late Mr. Omase was an employee of the defendant from 1st March 2000 until his demise in 22nd January 2016. The claimant is the younger brother of the deceased and the holder of letters of administration over the deceased estate. In paragraph 7 of statement of fact, the claimant averred that the late Mrs. Omar Umi obtained a customary court order on 23rd March 2016, authorizing her to administer the estate of the deceased, and that this order was served. This order was served on the defendant. In March 2016, the claimant further averred that the defendant failed, neglected, and/or refused to pay the late Omase entitlement despite repeated demands. The present action was commenced on 25th October 2023, which is over 7 years after March 2016, when the cause of action allegedly accrued. The defendant contends that by virtue of Section 16 of the Limitation Law of Rivers State, any action founded on contract must be brought within 5 years from the date the cause of action accrued. Since the cause of action accrued in March 2016 and the suit was filed in October 2023, it is statute bar. The claimant contends that limitation law no longer applies to contracts of employment following the Supreme Court decision of NRM AFC versus Johnson, and that in any event, the acknowledgement of debts in 2021 revived the cause of action. This court acknowledges that there have been decisions of this court, such as Lilian Nana Akuma versus First Bank of Nigeria PLC and Mr. Godson Ikechukwu Nkume versus First Bank of Nigeria Limited, which held that limitation laws do not apply to contracts of employment. Those decisions were premised on the interpretation of Supreme Court's decision in NRM AFC versus Johnson. However, with profound respect to the learned judges who decided those cases, this court must examine the true ratio of the Supreme Court's decision. The current position of this in National Revenue Mobilization and Fiscal Commission and two others versus Ajibola Johnson, the Supreme Court was considering whether Section 2A of the Public Officers Protection Act stated, "There is no doubt a careful reading of the respondent's claim will show clearly that it is on contract of service. It is now settled law that Section 2 of the Public Officers Protection Act does not apply to cases of contract." It is crucial to note that the Public Officers Protection Act is not a general limitation law. It is a special statute that provides protection to public officers for acts done in the execution of public duty, with a limitation period of 3 months. The Supreme Court merely reiterated the established exception that Public Officers Protection Act does not apply to breach of contract cases. The decision in Revenue Mobilization and Johnson did not purport to overrule or render inapplicable the general limitation laws of the various states of the Federation, including the limitation law of Rivers State, which specifically governs actions founded on simple contracts. The Supreme Court has consistently affirmed the applicability of limitation laws to contract of employment in Union Bank of Nigeria PLC versus Prince Nwokocha, Ezekwe, and another 2026 Law Pavilion Electronic Law Reports. The Supreme Court per Garba JSC stated, Section 8 of 1A of the Limitation Law of Lagos State provides that all civil action to be filed, initiated, or commenced in a court of law which arose from or are founded on simple contract between the parties shall not be filed, initiated, or commenced after the expiration of 60 years from the date the cause of action accrued to the claimant or party aggrieved, After the expiration of the period of 6 years from the date the cause of action, the cause or right of action accrued, the commencement or initiation of any such action is statutorily barred, prohibited, and rendered invalid in law. See also Ethiopia Airline versus Polaris Bank citation provided, where the Supreme Court reaffirmed that action founded on simple contract are subject to limitation periods. On the issue of whether negotiation or acknowledgement of debt can revive a statute-barred action, Section 28(7) of the Limitation Law of Rivers State provides, subject to subsection 6, a current period of limitation may be repeatedly extended under this section by further acknowledgement or payment, but a right of action once barred by the law shall not be revived by any subsequent acknowledgement or payment. This provision is clear and unambiguous. Once a right of action is barred by the expiration of the limitation period, no subsequent acknowledgement or part payment can revive it. In this case, even if the defendant's letter of 18 November 2021 constituted an acknowledgement of debt, the cause of action had already become statute barred by March 2021, 5 years after March 2016. Therefore, the acknowledgement in November 2021 cannot revive the action. On the argument that gratuity and pension entitlements are protected by Section 173 of the 1999 Constitution, that provision relates to pension right in the public service of the Federation. The deceased was an employee of a private limited liability company, not a public servant. The Supreme Court in Okoronko versus INEC reiterated the principle of expression, unius exclusion, ulterius. The express mention of one thing is the exclusion of another. Section 173 expressly refers to public service and therefore does not apply to private employment. See Abdurrahman versus NMPC, where the employment in question was with NMPC, a public corporation. The law is well settled that in determining whether an action is statute bar, the court must look at the originating processes, the complaint and statement of facts alleging when the wrong was committed, which gave the claimant a cause of action, and compare that date with the dates on which the action was filed. See Egbe versus Adefarasi number 2, Union Bank of Nigeria PLC versus Ezekwe, Ethiopian Airline versus Polaris Bank, all citations provided. From paragraph 7 and 8 of the statement of facts, the cause of action accrues in March 2016 when the customary court order was served on the defendant and the defendant allegedly failed to pay the deceased entitlement. The suit was filed on the 25th October 2023, period of over 7 years. Section 16 of the Limitation Law Rivers State, Cap 80 Laws of Rivers State 1999 provides, no action founded on contract, tort, or any other action not specifically provided for in parts 1 and 11 and 2 of this law shall be brought after the expiration of 5 years from the date on which the cause of action accrued. This provision applies to contracts of employment. The decision in National Revenue Mobilization and Fiscal Commission versus Johnson did not hold otherwise. It only held that the Public Officers Protection Act does not apply to breach of contract cases. The consequences in that, the claimant's action is statute barred. A statute barred action is dead, and the court is robbed of jurisdiction to entertain it, as stated by Anugolo JSC in Lasisi versus AG Oyo State. What is there to try when the statute has provided that the period allowed for bringing an action in which those facts which have been in issue has expired absolutely nothing. Accordingly, this court lacks jurisdiction to entertain these suits. The motion on notice dated 26 February 2024 is hereby granted. This suit is dismissed for being statute bar. Well, having found that this court lacks jurisdiction to entertain this suit by reason of the action being statute bar, this court does not proceed to determine the substantive case on the merit. However, for the avoidance of doubt, and in the alternative, this court shall briefly address the substantive claims. The claimant's case, as presented in the statement of facts and witness statement of Mr. Lewis, is that this late brother, his left brother, Mr. Omase, was employed by the defendant from 1st March 2000 until his demise on 22nd January 2016. The deceased allegedly collapsed at the defendant's office premises on 18th January 2016, was treated at Shawan Medical Center, and died on 22nd January 2016. The claimant averred that the deceased was the grade level 10 with a monthly gross pay of 607,273. The claimant contended that the defendant owed the deceased 4 months accrued salary, made unauthorized deduction from the deceased salary in May, June, July, and August 2015, totaling 516,547 naira for Kobo, failed to pay the deceased annual leave allowance for 2015 in the sum of 506. I will go there based on the claims. The claimant tendered several documents at the hearing of the matter, including the letters of administration, Exhibit C1, death certificate, Exhibit C2, defendant's staff manual 2009, Exhibit C8, payslip C7, and the defendant's letter of 5th April 2016, Exhibit C12. The defendant case. Then issues for determination. From the pleadings and evidence adduced, the following issues arise for determination in the substantive case: whether the claimant has the local standing to bring this action on behalf of the estate of the deceased, whether the defendant's staff manual 2009 Exhibit C8 was validly amended by the town hall meeting of 27th May 2014, Exhibit D1, whether the deceased entitlements are governed by Exhibit C8 or as amended by Exhibit D1, whether the claimant has proved his entitlement to the relief sought. Then summary of parties' final written submissions. Then court's decision. Notwithstanding the earlier ruling that this suit is statute bar, and in alternative, this court shall briefly state its finding on the substantive claim, the central dispute in this case revolves around the proper construction of the contractual relationship between the deceased employee and the defendant employer. The claimant relies on the defendant's staff manual 2009 Exhibit C8 as the governing document. The defendant contends that the staff manual was amended by town hall meeting in 2014. The claimant is the holder of letter of administration over the estate of the deceased, issued on 11th October 2023. By virtue of Order 11, Rule 1A and B of the National Industrial Code of Nigeria Civil Procedural Rules 2017, the legal representative of a deceased person may bring an action on behalf of the estate. The defendant's argument that the claimant lacks locus because of the late Mrs. Omawumi authorized Jemide Lawal authorized Ms. Ise Jemide to deal with the matter is of no moment. The letters of administration supersede any informal authorization. The claimant has locus standi. the unbinding nature of the law is settled that parties are bound by the terms of their contract of employment. The celebrated case of 7-Up Bottling Company, PLC versus Ajayi, the court held, it is well stated in many authorities that a condition of service is the bedrock upon which an aggrieved employee must found his case. Therefore, in a matter of contract of service, the court will not look outside the terms as stipulated or agreed to therein to decide the rights of the parties. Also in Olusanya versus UBA PLC, Court of Appeal held that any modification of an employment contract, whether through collective agreement or other means, must be explicitly incorporated into the contract to be enforceable. Section 7 sub 4 of the Labor Act stipulates that any change in the terms of employment must be documented and communicated to the employee. This court in Equema Aja versus Fidelity Bank, suit number NICNLA/588/2017, held that the retroactive application of a policy variation will be ineffective against an employee where it divests the employee of accrued benefit because the court does not protect retroactive action capable of denying accrued benefit. On issue 1, the claimant hold valid letters of administration Exhibit C1 over the estate of deceased. The fact that the late Mrs. Omawumi Jami Delawal may have authorized another person to act does not invalidate the claimant's subsequent grant of letters of administration by a competent court. The defendant's argument on this issue is unmeritorious and hereby dismissed. On issue 2, the defendant rallies on Exhibit D1, the minutes of the town hall meeting of 27th May 2014, to argue that the Staff Manual 2009 was amended. This court finds that Exhibit D1, even if it represents a decision of the defendant, does not constitute a valid amendment of the employment contract between the defendant and the deceased for the following reason. 1, there is no evidence that the deceased attended the said meeting or was notified of the decision taken therein. 2, there is no evidence that the deceased consented to the said amendments. 3, the purported amendment seeks to have retroactive effect, reducing benefits that had already accrued to the deceased based on his years of service before 2013. As held in Equoma Aja versus Fidelity Bank PLC, the court does not protect retroactive action capable of denying accrued benefits. On issue 3, since the purported amendment is inactive, the employment relationship between the defendant and deceased is governed by Defendant Staff Manual 2009 Exhibit C8. The provision of Exhibit C8 are binding on both parties. On issue 4, having found that Exhibit C8 governs the employment relationship, this court will have proceeded to assess the claimant's claim based on the provisions of Exhibit C8. However, by reason of the earlier ruling that this suit is statute bar, the court does not proceed to make final determination on the specific reliefs. Nevertheless, the court observes in passing that the defendant's own letter of 5th April 2016 Exhibit C12 to the Abara District Customary Court listed the benefits due to the deceased as including terminal benefits due from Syscon Nigeria Limited 8,411,467 naira 55 kobo, Group life insurance benefit 19,966,338 kobo. Furthermore, the defendant's letter of 18 November 2021, Exhibit D2, acknowledged the outstanding terminal benefit of 5,607,645 naira 3 kobo. This document suggests that the defendant itself acknowledged obligation to the deceased estate. However, as the action is statute bar, the court cannot enforce this obligation. In the alternative, this court finds, in conclusion, this court on the main case, this court finds that the claimant has local standing to bring this action. The purported amendment of the staff manual via the town hall meeting of 27 May 2014 is ineffective as against the deceased employee for want of communication and consent and being retroactive in effect. 3, the defendant's staff manual 2009 Exhibit C8 governs the employment relationship between the defendant and the deceased. And 4, the claimant will have been entitled to judgment based on the provision of Exhibit C8, subject to the proof of specific computation. In conclusion, for the reasons stated in the ruling on the motion, this court finds that claimant's action is statute barred having been commenced outside the 5-year limitation period prescribed by Section 16 of the Limitation Law of Rivers State, Cap 80 Laws of Rivers State 1999. The court lacks jurisdiction to entertain this suit. The suit is hereby dismissed. All the relief sought by the claimants are accordingly refused. This is the judgment of the court. No order as to cost.
As a court, please.
Yes.
My Lord, we must sincerely express our profound gratitude to the court's appreciation of the issue of jurisdiction raised. I think for the first time, we have seen a clear situation where my Lord went in to look at the issue of the earlier positions of the court on the issue of statute bar. And my Lord, this decision will no doubt lay a fresh precedent which subsequent decisions will follow, because I know that this is a burning issue and this decision has clearly clarified it. So we are so grateful for that judgment.
Yes, there are decisions from my learned brothers from Lagos and Abuja in that regard. Only that I did not go through them on the issue of application of limitation law. And yes, our court has always briefed us on the development. Our president has always been serious on those issues. Whenever there is development from the Supreme Court, he always sent to us so that we take note of it.
As a court,
thank you.
My Lord, we are grateful.
Yes, Registrar, call the next case, please.
NIC Oka, are you out there?
Yes, we are here. We are here.
Yes.
So,
yes.
NICN/Oka/14/2017 between Mr. Lawson Oradia and Omega Maritime and Energy Limited. Parties are absent. Counsels, announce your appearance.
Please.
With respect to this honorable court, my name is E.
Wait.
Oh,
Beloved,
okay.
say you should wait. Exercise patience.
Okay.
Yes, appearances, please. Parties absent?
Yes, well, the claimant is absent.
Okay.
Defendant
Defendant?
absent.
All right.
Well,
Parties absent. Appearances, please.
Okay. With respect to this
Announce your
honorable,
appearance.
my
Yes.
name is Omoefe Okoro.
Please, louder, please.
Okay. E as
E.
elephant, my lord, are my
Yes.
initials.
Yes.
Omoefe, Omoefe.
OMOEME.
EF,
Yes.
F for Igbo, E
Yes.
Okoro.
All right. Yes.
My humble appearance
most
for the claimant.
For the claimant.
Yes, my lord.
Yes.
most respectfully,
Yes.
Your Lordship,
Yes.
CC Azogu.
Yes.
My humble appearance is for the defendants, and I appear with my
Yes.
learned friend, G.U.
Yes.
Abo. We're most obliged.
With GU.
Abogu
Yes.
for the defendants.
Yes. The matter is for judgment and it is ready. This is an old case filed since 2017. The claimant commenced this action by a writ of summons and statement of facts filed on 16 May 2017 pursuant to an order of this court made on 2nd December 2020. The claimants filed an amended statement of facts on 7th December 2020. The defendants filed its consequential amended statement of defense and counterclaim on 8th March 2021. And the claimant filed a reply to the statement of defense and defense to counterclaim. The claimant's claims as contained in the amended statement of facts are as follows. A, the sum of 36,011,000 naira only representing salaries due and unpaid after paying 5% tax deduction. The sum of 1,632,000 only representing unpaid allowances for overtime worked. 10% interest on the judgment sum from the filing of the suit till judgment is delivered, and 10% interest on the judgment sum from delivery of judgment to final liquidation. The defendant's counterclaim 6A, declaration that the defendant is not liable to pay the salaries and/or entitlements of the claimant. B, a declaration that the claimant is not entitled to sums claims. C, an order dismissing the claimant's claim. This court has carefully considered the pleadings, the three written statements on oath of the claimant CW1, the written statement on oath of Mr. Eko Ekwe Emoke CW2, the written statement on oath of the defendant witness DW1, all the exhibits tendered and admitted, the final written addresses of counsel and the applicable laws. Case of the claimant. These ones are facts within your pleading, so you know about them. Due to time factor, I will not read them. I will go straight to the objection. There is an objection as to the admissibility of documents.
As God pleases.
The defendant objected to Exhibit CW1L timesheet and in part of Exhibit CW1A demand letter on ground that they were unsigned photocopies not supported by foundation for secondary evidence. By virtue of Section 12, sub 2B of the National Industrial Court Act 2006 and Order 1 Rule 92 of the National Industrial Court Civil Procedure Rules 2017, this court has the power to depart from the strict rules of evidence in the interest of justice. Sorry, my distance is too off. In the interest of justice. This is specialized labor court. Technical rigidity must not defeat substantial justice accordingly. The objection to Exhibit CW1L is overruled. The document is admitted, but its probative value will be assessed together with other evidence. The objection to Exhibit CW1A is overruled on similar grounds. The court notes that the claimant's identity card CW1C was admitted and the allegation of forgery was not proved beyond reasonable doubt as required by law. See Akoti versus INEC. Then I go to issues for determination. From the pleadings, evidence, and addresses in the following issues are distilled. One, what is the true nature of the employment relationship? Was the claimant a direct employee of the defendant, a contract staff of EMUPAC, or a co-employee under the joint employer doctrine? Two, whether the October-November 2012 flood and the termination of the total E&P contract automatically terminated the claimant's employment, or whether the employment continued. Three, whether the claimant has proved his entitlement to the relief claim on paid salaries and overtime on a balance of probabilities having regard to the flexible evidence regime. Four, whether the defendant is entitled to its counterclaim. It is a fundamental principle of contract law that a contract cannot impose obligation or confer right on a person who is not a party to it. The Supreme Court in Nwokoro versus Nwosu held a transaction between two parties ought not to operate to the disadvantage of a third party. Therefore, the manpower service agreement between the defendant and EMUPAC cannot by itself terminate or vary the claimant's direct contract of employment with the defendant. The Supreme Court in Lunge versus First Bank of Nigeria PLC identified three categories of employment: pure master servant, offer held at pleasure, employment with statutory labor in a master servant relationship. The employer may terminate at any time but must comply with the terms of the contract. The National Industrial Court has developed the co-employer or joint employer doctrine in triangular employment arrangement. The end user of labor who exercises control over the worker is considered a co-employer, jointly and severally liable with the manpower agency. See Captain Yahya Zande Wambai versus Bourbon Interior Nigeria Limited and another, unreported but well established in National Industrial Court jurisprudence. The court applies this doctrine to prevent employers from evading labor obligations through third-party arrangements. Allegation of forgery in civil cases must be proved beyond reasonable doubt. See Okoti versus INEC. Pa Tanko Muhammad, CJN of blessed memory, held that where a plaintiff avers that a document is a forgery, he must plead and provide particulars of forgery. The standard required is proof beyond reasonable doubt. The defendant failed to meet this standard. The National Industrial Court may depart from, as I earlier stated, may depart from Evidence Act in the interest of justice. This was applied in Federal Government of Nigeria versus Academic Staff Union of Universities and affirmed by the Court of Appeal in Mr. Victor Adeboyu versus United Bank of Africa, delivered on 14 April 2022. This court adopted the same approach. I will now go to the the Court of Appeal in Governor of Kogi State versus John held a contract of employment entered into in writing can only be terminated in writing. The defendant issued no letter of termination to the claimant. Therefore, the employment contract remained alive. In the force majeure does not automatically terminate employment. In Globe Spinning Mills Nigeria PLC versus Reliance Textile Industry Limited, the court defines force majeure as something that is unexpected and unforeseen happening, making nonsense of the real situation envisaged by parties. However, force majeure only excuses performance temporarily. It does not, without more, terminate a contract of employment. The employer must give notice or pay in lieu of notice. In Skybank PLC versus Adegum, the Supreme Court held that where a contract of employment is brought to an end by the employer contrary to the terms agreed, the quantum of damages cannot be limited to the salary in lieu of notice. The court may award damages that take into account the consequential loss, including stigma to the employee's character and the difficulty in obtaining alternative employment. The court also emphasized that Section 7 sub 6 of the National Industrial Code Act requires the court to have regard to the international best practice in labor relations. The traditional rule in Nigerian Produce Marketing Board versus Adeumi, that damages are limited to the period of notice, has been modified by Skybank PLC versus Adegun in appropriate cases. Section 167D of the Evidence Act 2011 provides the court may presume that evidence which could be and is not produced will, if produced, be unfavorable to the person who withholds it. The Court of Appeal applies this in Adekoya versus State of Lagos. The claimant's failure to produce his international passport, despite notice, entitles the court to draw an adverse inference. The court finds that the claimant was a direct employee of the defendant, and in the alternative, the defendant is a co-employer jointly liable with EMUPAC. Direct contract of employment exhibit CW1K is on the defendant's letterhead, signed by its human resource manager, offering the claimant the position of chief mechanic at a fixed monthly salary. There is no mention of EMUPAC in that letter. This is the foundation of the relationship. Control and supervision. The defendant, through its tool pusher, CW tool pusher, supervised the claimant. Monthly report was addressed to the managing director of the defendant. The defendant issues the claimant an identity card, even if irregularly signed, and introduce him to foreign embassies as our staff. Payment through EMUPAC is only a mode of disbursement. Many companies outsource payroll. That does not change the identity of the employer. The Supreme Court in Nwokoro versus Nwosu is clear that a third-party agreement cannot prejudice the claimant. Co-employer doctrine, even if the claimant could be considered an employee of EMUPAC, the defendant retained control over his work, designation, and discipline. Under NICN jurisprudence, the defendant is a joint employer, jointly and severally liable for unpaid entitlements. Conclusion on issue 1, the claimant was at all material times a direct employee of the defendant or alternatively, the defendant is his co-employer. The court rejects the defendant's argument that the flood and the termination of the total E&P contract automatically ended the claimant's employment. No letter of termination. The defendant issued no letter of termination to the claimant. Employment, be it a written contract, could only be terminated in writing. See Governor of Kogi State versus John. Contemporaneous documentary evidence, monthly report of October 2012, page 34 to 35 of Statement of Facts, states verbatim, all staff were sent back to Port Harcourt, Papa Hotel, while the tool pusher, chief mechanic, and chief electrician were put on standby. The Omega crew on standby to date have been rendering services to SW1, OB125, WOCAM, and wherever they are needed. This is powerful evidence that the claimant was retained and continued to render services. Delivery note of 19th December 2012, the coffee maker delivery note signed by a total E&P staff shows the claimant was active on site in December 2012. Introduction letter of 21st December 2012, the defendant introduced the claimant to the American Embassy for company-sponsored training. That letter would not have been written if the employment had ended in November 2012. Okay. Delivery note of 18th March 2013, the generator radiator delivery note shows activity in March 2013. Grievance letter of 28 February 2013, the claimant and other workers wrote to the defendant's managing director, complaining about unpaid salaries, allowances, and other conditions. That letter is an unequivocal admission by all parties that an employer-employee relationship still subsisted in February 2008, as held in Glove Spiny Mills Supra. Force majeure is a temporary excuse, not a termination. The defendant could have declared redundancy or give notice. It did neither. Conclusion on issue 2. The claimant's employment continued after the flood. The defendant cannot rely on its own lack of work to deny salary when it failed to terminate the contract lawfully. The court must now determine what reliefs the claimant is entitled to. A, overtime, 1,632,000. The overtime claim relates to June, July, and September 2012, a period when the claimant was indisputably working on the rig. The timesheet CW1L is admitted under the flexible evidence rule. The defendant did not produce its own timesheet to contradict it. The claim is specific, 51 days of 32,000 per day, 1,632,000. This relief is granted in full. Then unpaid salary of 36,011,000. The claimant asked for full salary for 50 months. However, the evidence does not support continuous full-time work for every month. There is no evidence of work performed in many months, especially during 2014 and 2015. The claimant also failed to produce his international passport, and the court draws an adverse inference under Section 167D of the Evidence Act that the passport will have shown long absence. Nevertheless, the defendant is not without liability because the defendant kept the employment contract alive by not terminating it, retained the claimant on standby as per CW2 report and continued to treat him as an employee. Introduction letters, grievance letter, the court will award damages for breach of contract. The claimant was not given the notice of which he was entitled, nor was he paid for the period when he was ready and willing to work, but no work was provided. Following the modern approach in Skybank PLC versus Adegu, the measure of damages is not limited to 1 month's salary in lieu of notice. The court must do substantial justice. The award: 1, salary for the initial 7 months, April to October 2012. This period is reasonably proved and not seriously disputed, which is calculated to be 5,985,000. 2, damages in lieu of notice. The claimant was a senior staff chief mechanic in the oil and gas industry. A reasonable notice period is 3 months. The defendant failed to give any notice. The court award 2,565,000. The claim for full salary for the remaining months is refused because the claimant did not prove he worked or was available for work during those months. The adverse inference from the withheld passport reinforces this. Total for unpaid salaries damages 5 million plus 5,985,000 plus 2,565,000, which is equal to 8,550,000. Interest awarded is 10% per annum until final liquidation. That's post-judgment interest. The counterclaim, the defendant's counterclaim seeks declaratory reliefs that it is not liable and that the claimant is not entitled to his claim. Having found the defendant partially liable and the claimant partially entitled to his claims, the counterclaim is dismissed in its entirety. The judgment is entered as stated and no order as to cost. By Tuesday, you will have a copy of your judgment, certified true copy, because it is in my own typesetting. So when I give to my secretary, she will correct the typesetting and release the certified true copy of the judgment to the parties by latest by Tuesday next week.
As it is.
We're very grateful to my Lord.
Yes.
Suit number 3. Are you there? Cancel.
Yes, yes, we are here.
Is it my case? I don't know. Which one is number 3?
Barrister Felix and
the only case that remains.
Silas Daisy Ukawa and Awakse Nigeria Limited.
Yes, we are here, madam. Yes, we are here.
Barrister Soti and Barrister Tegeye.
Yes, we are here.
That's 10.
NICN/PAC/10/2024 between Silas Daisy Ukawa and Awakse Nigeria Limited. Parties are absent.
Okay.
Thanks and announce your appearance.
With due respect.
Yes, appearances, please. Yes.
B.O. Tedeye, Mrs. My appearance is for the claimant.
Yes.
May it please this honorable court. My name
Yes.
is G.N. Akujo.
G.N.
Akujo.
Akujo.
Akujo is, yes, Akujo is spelled A-K-U-J-U-O.
A-K-U.
J,
A-K-U.
yes, my
J.
lord. J-U-O.
Okay.
I most
J-U-O.
humbly announce my appearance for the defendant.
Yes. Yes, the matter is for judgment and it is ready. The claimant commenced this suit by a complaint dated and filed on the 22nd day of February 2024. The claimant seeks against the defendant the following reliefs. 1. A declaration that the claimant is entitled to his unpaid salary in lieu of termination of his appointment and all other entitlements as enshrined in the letter of employment. 2. An order directing the defendant to pay the claimant the pension tax deductions made from the claimant's salary for 4 years. 3. An order directing the defendant to pay the claimant the sum of $4,080,000 being claimant's annual bonuses for 8 years. 4. An order directing the defendant to pay the claimant the sum of $10 million as general damages. 5. And for further orders as this court may deem fit to make in the circumstance. The claimant filed alongside the complaint a statement of material facts, list of witnesses and documents to be relied upon, and a verification affidavit. The defendant filed a preliminary objection challenging the jurisdiction of this court to hear and determine suit on the grounds that the suit did not comply with Section 97 and 99 of the Sheriff and Civil Process Act, among other grounds. The court delivered its considered ruling on the 2nd day of October 2024, overruling the preliminary objection. Thereafter, the defendant filed its statement of defense on the 21st day of October 2024, along with a list of witnesses, list of documents, and written deposition on oath of Dorothy Sedi. The claimant filed a reply to the statement of defense and a further statement on oath on the 13th day of November 2024. The facts of the case, that's the claimant case and the defendant case, these are what you have in your pleadings. Because of time, I will not read them. I will go straight to the issues for determination. In the claimant's final written address filed on the 27th March 2025, the claimants formulated a long issue for determination. That is whether the claimant, in the circumstances of this case, is not entitled to the judgment of this court. While the defendant in his final written address, in the defendant's final written address filed on 14th March 2025, the defendant formulated two issues for determination. That is whether the written deposition on oath of the claimant filed on 22nd February 2024 is not in violation of the Evidence Act 2011 and therefore incompetent. Issue 2, whether on the state of the pleadings and the evidence before this honorable court, the claimant has established his entitlement to the relief sought. The issues adopted by this court, the court adopts the two issues formulated by the defendant as they adequately capture the crux of the dispute between the parties. Summary of parties' final written address. These are all your final written address. Because of time, I will not read them. I will go straight to the decision of the court. This suit, the decision of the court, this suit emanates from the termination of the claimant's employment as chief engineer with the defendant, a marine transportation company. The claimant was initially employed on 15 February 2016, and his contract was reviewed upward on 4th April 2020. He fell ill in September 2022, was treated at the hospital train retained by the defendant, and was certified fit to resume work. However, he was not posted back to work. In May 2023, his employment was terminated via a letter sent to his WhatsApp. The claimant seeks payment of salary in lieu of notice, pension tax deduction for 4 years, annual leave bonuses for 8 years, and general damages. The defendant contends that the termination was valid, that the claimant was given 1 month notice as required by his contract, that his June 2023 salary was paid in December 2023, that pension deductions have been remitted, and that the claimant is not entitled to leave bonuses and worked on a 1 month on, 1 month off basis. The law recognizes 3 categories of contracts of employment. The Supreme Court of Guntade JSC identified them as purely master and servant relationship, servants who hold their office at the pleasure of the employer, and the third one, employment with statutory level. In a pure master and servant relationship, the master has the unfettered right to terminate the employment provided he complies with the procedure stipulated in the contract. In Damisa versus UBA, the Supreme Court held that a mere contract of employment is guided by the agreement of the parties, and the only remedy available for wrongful dismissal is a claim for damages, not reinstatement or declaration that the termination is null and void. In Skybank PLC versus Adegum, the Supreme Court, by Agim JSC, held that where a contract of employment is terminated by of damages cannot be based solely. The burden of proof is on the claimant. In Folarin versus Augusto, the Supreme Court per Okoro JSC held, in all civil cases, the burden of proof lies on whoever desires the court to give judgment as to any legal rights or liability dependent on the existence of facts which he asserts to have existed. Indeed, the burden of proof lies on the party who will fail if no evidence at all were given on either side. Also, the Court of Appeal held, per Loku Shodifo of blessed memory, reiterated that onus of proof in civil matter lies on the plaintiff to establish his case upon preponderance of evidence. The standard of proof in civil cases is on the balance of probabilities or preponderance of evidence. See Emeka versus Chuba Ikpezu per Ogumbi JSC. In Damisa versus UBA Supra, the Supreme Court held, in contract of employment governed only by agreement of parties and not by statute, removal of employee by way of termination of appointment or dismissal will be in the form agreed to. Any other form connotes wrongful termination or dismissal, but not to declare such dismissal null and void. Also in Ovivu versus Delta State Company Limited, the Supreme Court per RGJSC held, the court must confine itself to the terms of contract of service between the parties, which provides for their rights and obligations. Generally speaking, a master can terminate the contract of employment with his servant at any time and for any reason or for no reason at all, provided the terms of contract of service between them are complied with. On issue 1, whether the written deposition of oath of claimant filed on 22nd February 2024 is incompetent for violation of section 117(1)(b) of the Evidence Act 2011. The court has carefully examined the claimant's witness statement on oath filed on 22nd February 2024. The document is titled Statement on Oath and contains the following at its commencement. I quote, I, Silas Desi Ukawa, male adult Christian Nigerian citizen, staff of Awari Tise Nigeria Limited, now residing at number 5 Emmanuel Street off Aka Road, Rumolomeri, Obio Akwa local government area of River State, do hereby make oath as said as follows. On court. The court finds that the deposition states the deponent's name, nationality, and residence. Local government, however, the deposition does not explicitly state the deponent's trade or profession as required by section 117 sub 1B of the Evidence Act 2011. The defendant argued that this omission renders the entire deposition incompetent. The court must first address a fundamental distinction in law, the distinction between an affidavit and witness statement on oath. The law draws a clear distinction between an affidavit and a witness statement on oath filed in the course of proceedings. This distinction was authoritatively settled by the Court of Appeal in Aliu versus Blackie, citations provided, where the court held, and I quote, an affidavit is a sworn statement of facts made by a deponent who swears to its truth based on his personal knowledge or information derived from others. It is used primarily in interlocutory application and originating processes. The formal requirements for affidavit, including those under section 117 of the Evidence Act, are strictly complied because the deponent does not subsequently appear in court for cross-examination on the contents. A witness statement on oath or written deposition on oath is a document prepared for the purpose of giving evidence in chief at trial. It is a formal out-of-court statement that is adopted by the witness in court under oath. The witness then becomes available for cross-examination. Any initial defect in the form of a witness statement on oath is considered curable when the witness appears in court, confirms the truth of the statement, and adopts it as his testimony, subjecting himself to cross-examination on court. The court in Aliu versus Bulaki further held that where a witness appears in court, is sworn, adopts his written statement as his evidence in chief, and is cross-examined on it, the witness statement on oath becomes his oral testimony reduced to writing. The court can then act on it even if it had initial technical defects, provided the witness has confirmed its truth under oath in court. In this case, the claimant was sworn in court on 16 December 2024. He formally adopted his witness statement on oath dated 22nd February 2024 as his evidence in chief. He was thereafter thoroughly cross-examined by the learned counsel for the defendant. The defendant did not raise any objection to the competency of the witness statement at the time it was tendered or before the claimant adopted it. The objection was raised for the first time in the defendant's final written address after the conclusion of trial. Applying the principle in Aliu versus Bulaki, the court finds that the claimant's appearance in court, his adoption of the written statement under oath, and his submission to cross-examination cured any initial defect in the form of technical irregularity that does not go to the substance of the deposition. Sorry, I will take it again. Applying the principle in Aliu versus Bulaki, the court finds the claimant's appearance in court, his adoption of the written statement under oath, and his submission to cross-examination cured any initial defect in the form of the witness statement. The omission of the trade or profession is in any event a technical irregularity that does not go to the substance of the deposition. The claimant's profession as a chief engineer is readily discernible from the contents of the deposition. Furthermore, the defendant, having become aware of the alleged defects at the time of filing his statement of defense on 21st October 2024, proceeded to participate fully in the trial without raising a preliminary objection on the grounds on this ground. In Enterprise Bank versus Arose citations provided, the Supreme Court held that where a party becomes aware of the defect and participates fully in the suit, it has acquiesced and cannot turn around afterwards to complain. The court also notes that the claimant filed a further statement on oath dated 13th November 2024, which was not challenged by the defendant on this ground. That statement substantially repeated the same identifying information. Accordingly, this court resolved issue 1 in favor of the claimant. The technical omission of trade or profession does not render the witness deposition on oath incompetent. The deposition is properly before the court and it is admissible in evidence. The court will, on issue 2, the court will examine each of the claimant's relief in light of the pleadings and evidence. On relief 1, declaration that the claimant is entitled to his unpaid salary in lieu of termination of his employment, appointment, and all other entitlements as enshrined in the letter of employment. This is a declaratory relief. In Oguru versus Okowa, the Supreme Court held that a party who seeks declaratory relief succeeds only on the strength of his case and not on the weakness of his adversary's case. The contract of employment between the parties is contained in Exhibit C1. The termination clause is Exhibit C2, which provides the length of notice which you are entitled to receive from the ship owner to terminate your employment is 1 month. The claimant was issued Exhibit C3, Notice of Termination of Appointment, dated 25th May 2023, which states that his employment will no longer be required with effect from 26 June 2023. This constitutes 1 month's notice of termination. The law is settled that payment in lieu of notice is only an alternative where the required notice has not been given. In Mobile Producing Nigeria Unlimited versus ASU and ODSA versus Auchi Polytechnic, the courts held that once the agreed period of notice or payment of salary in lieu thereof has been given, it prevents the termination from being wrongful. The claimant admitted under cross-examination that he received the termination letter in May 2023. The notice period expired on 26 June 2023. The claimant claimed that his salary was not paid, but Exhibit D1 shows that the claimant's June 2023 salary was paid in December 2023. The claimant did not challenge the authenticity of Exhibit D1. The court finds that The claimant was given 1 month notice of termination as required by his contract. He is therefore not entitled to salary in lieu of notice. Regarding other entitlements, the claimant has not specifically pleaded or proved what other entitlements remain unpaid. This relief fails. On relief 2, an order directing the defendant to pay the claimant the pension tax deduction made from the claimant's salary for 4 years. The claimant pleaded that the defendant did not remit tax deduction from his salary for 4 years to his pension manager, Access Pension. The defendant tendered Exhibit D2, a schedule of pension contribution showing remittance to Sigma Pension Limited. The defendant witness testified that remittance were made to Sigma Pensions, not Access Pension. The claimant in his reply filed on 13 November 2024 did not specifically deny the defendant's averment that pension deductions were remitted. Under Section 123 of the Evidence Act 2011, facts admitted need no further proof. In Bongo versus Governor of Adamawa State, 2013, citations provided, the court held that facts not specifically denied are deemed admitted. However, there is discrepancies between the claimant's claim pension manager, Access Pension, and the defendant's remittance destination, Sigma Pension. The claimant's Exhibit C4 is a pension statement from Access Pension. The defendant's Exhibit D2 shows remittance to Sigma Pension. The court finds that the defendant has made pension remittance, but not necessarily to the claimant's designated pension fund administrator. The claimant is entitled to have his pension contribution remitted to his choosing PFA. The court will order the defendant to provide evidence of remittance to the claimant's Access Pension account or to pay over the unremitted deduction to the Access Pension. On Relief 3, an order directing the defendant to pay the claimant the sum of $4,080,000, the claimant annual bonuses for 8 years. The court notes a discrepancy in the claimant's pleading. In the statement of material fact, the claimant claims annual bonuses of $4,080,000. However, in the further statement on oath, the claimant claimed $44,080,000. The court will proceed on the reliefs as stated in the complaint, that is $4,080,000. Exhibit C2 provides, you are entitled to take 30 working days as paid leave in each year of employment and leave entitlement of 10% of your annual basic. There is no provision for the transfer of paid annual leave from 1 year to the next. All paid annual leave must be taken in the year in which it accrues. There is also no provision for payment to be made in lieu of untaken leave except where paid annual leave has accrued but has not been taken at the date of termination of employment. The claimant admitted under cross-examination that he never took any leave during his 8 years of employment. He also admitted that he never made a formal application for leave. The claimant's assertion in his further statement on oath that the practice in the maritime industry is that employees proceed on annual leave at the eve of their employment and not to formally apply for same was not pleaded in the statement of material facts. In Vince International Limited, Nigeria Limited versus Morohundia, citations provided, the court held that evidence on facts not pleaded goes to no issue. The defendant's witness testified that the claimant worked on a 1 month on, 1 month off basis. This was not contradicted. In essence, the claimant worked approximately 6 months in a year. The entitlement to 30 working days of paid leave per year must be read in context of this work schedule. More fundamentally, the contract expressly provides that leave bonuses are only payable for leave actually taken, with a narrow exception for accrued but untaken leave at the date of termination. The claimant never took leave, and he has not shown what leave had accrued in 2023 before his termination on 26 June 2023. Under the contract, leave cannot be transferred from year to year, and there is no provision for payment in lieu of untaken leave except at termination. The claimant's employment commenced under Exhibit C1 in 2016, but the leave provision only appeared in Exhibit C2 of 2020. Even assuming the claimant was entitled to leave from 2020, he did not take any leave. The only potential entitlement will be for leave accrued between 4th April 2020, date of Exhibit C2, and 25th May 2023, date of termination notice, a period of about 3 years. However, the claimant has not provided evidence of his annual basic salary for the purpose of calculating the 10% entitlement. Exhibit C2 shows a monthly gross salary of 1,700,000, the annual basic salary 425,000, which is times 12, 5,100,000. 10% of that is 510,000 per year. For 3 years, that will be 1,530,000. But this calculation assumes the leave was not taken. Under the contract, leave bonuses are payable for leave taken, not for leave not taken. The court finds that the claimant has failed to establish his entitlement to 4,080,000 or any sum as annual leave bonuses. The clear terms of Exhibit C2 do not permit payment for untaken leave except at termination for accrued leave. The claimant did not take leave, and the termination accrued in June, so only a portion of 2023 leave will have accrued. This relief also failed. On relief 4, an order directing the defendant to pay the claimant the sum of 10 million naira as general damages. In Omera vs. NLC 2022-10 NWLR Part 1838, page 349 at 395. The Supreme Court held, however, general damages are not usually awarded in cases for wrongful termination of employment. See also Shena Security Company Limited versus Afro Park Nigeria Limited. Citation provided. And Salami versus UBN PLC. The claimant has not pleaded any special circumstances that will justify an award of general damages for wrongful termination. His employment was properly terminated with notice. The claim for 10 million general damages is without foundation and is refused. On relief 5, further orders as the court may deem fit. The claimant in his reply sought an order for declaration as unlawful the termination of the claimant. This was not one of the original relief in the complaint. The court has already found that the termination was in accordance with the notice provisions in the contract. The termination was therefore lawful. In the final analysis, the claimant's employment was validly terminated with 1 month notice as required by Exhibit C2. The claimant is not entitled to salary in lieu of notice. The defendant has made pension remittance, but the court is not satisfied that these remittance were made to the claimant's designated pension fund administrator excess pension. The claimant is entitled to have his pension contribution remitted to his choosing PFE, which is hereby ordered. The claimant is not entitled to annual 5.3. The claimant is not entitled to annual leave bonuses for 8 years, having never taken annual leave, and the contract expressly prohibiting payment in lieu of untaken leave except at termination for accrued leave. 4, the claimant is not entitled to general damages of 10 million. The court makes the following orders. The claimant's relief number 1, 3, and 4 are hereby dismissed. The claimant relief number 2 is granted in part. The defendant is hereby ordered to provide to the claimant within 30 days of this judgment proof of remittance of all pension deductions from the claimant's salary to his designated pension fund administrator, Access Pension. In default of providing such proof, the defendant shall pay directly to the claimant's Access Pension account all unremitted pension deduction within the same period. Each party shall bear its own cost. Judgment entered. That's the judgment of the court. Yes.
My Lord, we are grateful, sir.
Yes.
My Lord, we are grateful for the well-considered judgment. We appreciate it, my Lord.
Thank you.